Assalamualaikum everyone. I welcome you to the summer mentorship series, Mentoring Young Lawyer. Today, for mentorship, Basil Nabeen Malik has joined us. He is head of Ramco and has been in the legal field for many years and is also alumni. Today, he will be imparting his experience and knowledge based on which he'll be guiding you on how to form your courtroom skills and manage clients effectively, especially when you are starting your work. So, over to you, Basil.
Thank you. I hope you guys can hear me. So thank you first and foremost for inviting me for this. And I think I'm not gonna try to you know make this into kind of a lecture. I'm gonna try to kind of keep it brief, give you some pointers in relation to what I've picked up over the years when it comes to the litigation field and how to operate in it. And then perhaps from there, if we have any questions, etc., we can dive straight into that and take it from there. So there are essentially three aspects or things that I was asked to give my opinions about. One was in relation to client management and communication. There was courtroom and trial etiquettes, as well as transitioning from law school to practice. So the way that I'm going to do it is I'm going to start from the transition because I think that's what's most relevant for a lot of you guys. And then I'll proceed to client management and communication. And then finally, I'll end with courtroom and trial skills. So if we like get right into it, when it comes to transitioning from law school into practice, I think there's like a variety of things that we're all told about and we're asked to look into. I think some of the most uh, repeated pieces of advice usually to every new fresh grad is that go for the big firms, go for the firms that are very well reputed, have a great presence or a big presence throughout the country. Um, and then there's also aspects about pay and all of that stuff that is kind of in your minds when you're looking for the best job to start with. So I think if I were to now look back at everything from when I started out, and if I were to give myself some advice, as to how to go about it, there'd be probably around, I think, like four things that I would keep in mind. And it'd be these four things that I'd probably advise you guys or the, whoever would be so interested. And, keep these things in mind whenever you're going to be looking towards the law profession and trying to become a part of it. So the first thing that I always, would advise newcomers or people who are coming into this profession is that, don't go for the big name necessarily. I think that's usually and fundamentally the biggest mistake that a fresh graduate makes. A lot of them are looking more for the prestige aspect of it, that, okay, if we're associated with a big firm, that essentially means that we're going places. That's an affirmation of our skills and therefore that's the best possible way for us to go. But it kind of isn't like that. I mean, to eventually land up in a firm which is reputed, obviously everyone wants that and it makes sense. But whether that would be the right fit for you or others in the very beginning, now that is definitely questionable. And why do I say that? Because when you're looking for a job or where to start off, the most important things that you need to look at is, number one, who's the senior who's going to be guiding you. Is that senior going to be directly supervising? वो आपके साथ directly काम कर रहा है या वो दो तीन tiers हैं उसके नीचे और लोगों के और वो आपसे actually deal कर रहे हैं? What's the kind of exposure that you get? I mean, is this a law firm that already has like, multiple assets already available to them? Because if they do, then would you really be able to get the opportunities that you want? Would you really get the exposure that you want? The pressure situations, would they be available or not? So these are the actual questions that one would be thinking about. And I think when you go to a large firm, uh, in the beginning, you may not be getting things that you want. For example, uh, if you were to ask me, going into a mid-tier firm but getting direct supervision from someone who's senior is going to be a lot more profitable to you in the long run than in going to a large firm and never really interacting with the senior and just interacting with senior associates or associates who are like a few years over and above your experience level. So I mean that's more important, and you usually get those in mid-tier firms. You won't get those in the higher tier firms. Not all of them. I mean, you can't generalize. And generally, you know, in a mid-tier firm, you'll probably have less associates, which means that the direct contact and direct interaction will be more. And not only that, but your exposure, the amount of cases that you'll probably get to proceed with, the kind of opportunities you get in terms of the kind of cases you'll be experiencing or arguing, the responsibilities you'll get. You'll probably get that a lot quicker and a lot sooner in a mid-tier firm or a firm in which you have direct lines with the partner, as opposed to a firm which has a variety of tiers and has a big list of resources that they're going to be using, and you're just another addition to that. So, I mean, that's the first thing that I would advise everyone. Okay, don't look at the big firm names necessarily. Look at the big questions involved, actually. Just look at who's going to be supervising you, who are you in contact with, who's going to be looking at your work, who's going to be mentoring you, and what kind of exposure that will you get, and can you even get it in the type of environment that they offer or that firm specifically will offer. The second thing is, and I think this is not necessarily advice, but I think it's something that I would kind of tell myself if I was entering into this profession right now, and that is that this profession is somewhat unforgiving. And I think a lot of you perhaps already know this, but it is extremely unforgiving. So you have to be really patient in the beginning. You can't expect that you will see instant results. It's going to take a long time, and there are going to be long hours involved. You're going to be spending lots of time in the office. And a lot of the time you won't be paid as well as you want to be and as well as you should be for the work that you've done. But whilst, asking for a decent pay is absolutely fine and it makes sense, do keep in mind that no matter how little your pay may necessarily be, if you're getting good work and good experience, don't consider it as a waste of your time or that, I'm not getting paid enough for this, so I don't want to do this. Because in litigation or in the overall, law profession, every single hour you put in to the profession or into research, into drafting, into actual arguing, is an hour that you've in fact invested in your own future. So the initial 2, 3 years are always very tough, but after that, it's like a pyramid essentially. So the amount of experienced people that you have in the profession will decrease with each passing year. A lot of people leave the profession. They actually go into corporate, they'll go in-house, they'll go elsewhere. So in that sense, if you can stick it out and you get into this profession, you stay in this profession, after a few years, if you have that kind of knowledge base, what you will notice is that you will be highly valued, right? But that will be subject to you being able to invest in yourself, actually do the work. So just because you may not necessarily be paid well, does not mean that whatever you're doing is not valuable. It's extremely valuable, but may not be as valuable as you would want in terms of how they're paying you. But it's certainly valuable for your own subsequent progress in the profession. So just keep that in mind. And I think the last thing, and I think this is specifically important for people who come from universities such as perhaps LUMS or they've studied from abroad and they're coming back to Pakistan. You got to check your ego at the door when you're entering into this profession, because I think uh, there's a big humility factor that's involved when you come here. I mean, no matter how well you've done in your university or your school studies, it's just a totally different world out here. So never expect that when you're going to be entering this profession, just because you have a LUMS degree or whatever, any other degree, whether it be from abroad or here, that instantly you should be recognized as a great individual or someone who has a lot of skill. Um, as I noted, the degree is as good as simply getting your foot in that door. That's essentially all it does. So it'll get you that interview, right? So yeah, your degree is absolutely wonderful for that. It will get you into interview places, in interviews in a variety of good law firms. But what you do after that and what you do subsequently once you're hired is all up to you. No one will care about that degree. No one will ask about that degree afterward. And after a few years, the degree becomes less and less important, and your experience and your overall reputation in the market, that just becomes more and more important. So yeah, so I mean, we have to be remain humble, keep our egos in check, and understand that we're entering in a totally different field. So we gotta make sure that we work accordingly, and put our heads down and just work as hard as we can. So I mean, I think these are the basic things that I would advise anyone who comes into the profession. That just keep these things in mind. As long as you do that, you'll be fine. This profession is ruling in the first 3 4 years, but it does reward you eventually. Uh, I guess we just have to be patient about it, and if you're patient, we'll get there. If you move on to the second aspect, which is client management and communication. Now, I guess there are two aspects to this, and I think it's quite interesting actually. And I think you learn this over time after you deal with a variety of clients. Some of the clients will be extremely nice and good, and they'll be understanding, and then there'll be those clients who will absolutely not understand anything that you're actually saying. Will be extremely difficult. Will make perhaps issues out of the slightest of things. And your job as a lawyer is not only to argue their cases, it's essentially to manage their expectations and manage them. So when it comes to, client management and communication, what you have to keep in mind, and I think two things specifically. Number one, who is it? Who is this client that you're dealing with? You really have to be able to judge your client. Um, if I had a nickel for every single time that I came into contact with somebody who was willing to pay a good amount of money, but the client himself was extremely problematic or perhaps somewhat sketchy or um, just seemed like an extremely problematic personality, and I just refused to take the case. If I had a nickel for every time that happened, I probably wouldn't need to practice anymore. Because the problem is that even if you get a good client in terms of pay, that doesn't mean they're going to be a good client in terms of how they respond in terms of to a variety of situations that occur in your cases. So you have to first be able to assess that. So, for example, if a new client comes to you and says, "Look, I want to engage you in ABCD case, whatever that is," um, so a lot of people will at the very first instance, they'll quote a fee, they'll agree to the fee, they'll say, okay, we're engaged. But the problem in that is that you don't really get to know who that individual is. And the best way to kind of figure that out is to have that one-on-one conversation with them, but also other than that, to kind of see their case files, see what's happened so far in their files. So, for example, if you see a client who's been in litigation for the past 10 years, and has changed his lawyer around like 6 7 times, that's a red flag. You need to understand that there's something going on over there. Not every lawyer can be wrong. So what's happening here? Is there an issue with the client? If there's a client who comes into a meeting and despite you being the lawyer, essentially kind of tries to tell you what the law is or thinks that he knows the law better than you, that's a red flag, because then you have to understand then this is going to be a client who will be repeatedly doing this after you get engaged. So how will you deal with him? So I mean, the first step in any client management strategy has to be identifying who your client is and what kind of client he is. And the second part, and I think this is the most important, you manage their expectations. And that has to be done at the very beginning. You have to tell them at the very beginning what their case is, what their chances of success are, if there's going to be success at all, and what you plan to do and how you plan to do it. And once you do that, then you have to keep in constant communication with them. I think the biggest mistake that most lawyers make in this profession is that they just don't contact their clients and they just don't pick up their calls. They don't take their meetings. What they do is that they're attentive till the time that they get their professional fee. Once they get their professional fee, they essentially assume that the client will just leave everything to them and they just don't have to be told anything. But the problem is, clients don't get worried just because you lose an application or you win an application or there's a difficulty in your case or there's some other problem in your case. What I've noticed, usually clients don't mind those things. What they mind is not knowing of any of this. So if you are facing these difficulties, but your client is not in the knowledge of, in the know-how of it, you haven't told them anything, that's where the issues arise, because then a trust deficit, so to speak, occurs between you and your client, because they don't think that you're telling them the truth or the entire truth. So proper communications, perhaps email correspondence whenever a date takes place, these things are going to be extremely important. Um, So yeah, and when it comes to courtroom and trial skills, and I'm just giving pointers right now because I want that if people have questions, they have sufficient time to kind of do that. Um, so when it comes to courtroom etiquettes and trial skills, and what you need to look into when it comes to those things, I think a lot of it is kind of counterintuitive. We already know it, but I think it's just important to state it out loud. Just as you need to know your client, you need to know your judge, right? So it's extremely important. I think at least 50% of your case is about the judge you're arguing it before. Um, One judge may be, very procedurally minded, which means technical knockouts पे वो बहुत ध्यान देते हैं. Another judge will be very equity related. So he will not mind you being, the procedural issues being there. He will not put too much focus on that. He'd look at the equity of the situation. If your client, in his opinion, has been treated unfairly, he'll look for ways to kind of make that right. So he's kind of that kind of a judge who's looking at the fairness of the situation, not the technicalities of it. Right. So, and there are a variety of the judges. Certain judges will have certain views about service matters. Certain judges will have certain issues in relation to university related matters. Every judge has a certain mindset that they bring to the bench. It's your job as a lawyer to know what that is. Because like I can give my personal example, like there's a specific case that I may have. It may be about a university employment issue, and it may be fixed before four different judges in a span of like 2 years, right? And every single time the case will be the same, but I will have to draft separate arguments for each of those judges because every judge will have a different point which may appeal to him. And one point which may appeal to one of the judges will not appeal to the other. So I have to be very careful and have to readjust all my arguments accordingly. So, I mean, know your judge, very important. Learn how to, you know, talk to judges and kind of ensure that you take them along with you. One of the issues that we face in court is that a lot of the times the judges will straight up tell you, okay, your position on this is wrong. I feel that this is what the law says on XYZ position. The problem when when that happens is that whenever a judge gives you a very affirmative position, you can do one of two things. You can either say directly, no, sir, you're wrong. And this is not how what the law says. This is exactly what the law says. You do something like that, and in all likelihood, the judge will get affronted. He'll get insulted. He will feel as though his ego has been hurt, and it will make your life even more difficult, right? So you have to devise a way in which, even if a judge is confronting you with a situation, which perhaps is absolutely, in derogation of the law, or is in, is in total contradiction of what the settled law says, you have to find a way to tell him this without offending him, without making him feel as though, he's just been made to look like a fool in front of everybody in the courtroom. And that's the most important part of practicing. And that's a very important skill set that you're going to all have to kind of adopt. Like in our cases, if we find a judge is doing something of the sort, one of the things that we may do is we may simply say, okay, my lord, you're absolutely correct in your observation. However, in relation to XYZ case, this point of view has also been expressed. Something along that route that allows the judge enough leeway not to look like, he's just been showed up by a lawyer in court. So, I mean, be respectful of the judge, but be firm and find ways to articulate your thoughts which don't offend against his worldviews. Because judges are a lot more amenable to changing their worldview if they don't feel that they're being attacked or their worldview is being taken apart by you, right? So you got to develop that skill. And lastly, I think one of the most important things is, yes, you got to know your case inside out. So some of the things that lawyers do is that if you have a certain matter before you, and I think we do this in university as well. If you have a task before you, have a certain question, you'll limit yourself to that one question, right? You'll specifically say, okay, this is the question and this is the answer to that question. I'm done, right? You can't approach litigation like that. The problem over here is, even though you, after studying the entire file, know very well that the issues before the judge are, one or two, if you limit yourself or limit your preparation only to those one or two questions, you face the risk of being blindsided by a question that the judge may ask, which may not necessarily be in relation to those two questions, but either would be ancillary or would nonetheless be required to be answered so that the judge doesn't veer off into the wrong direction. So the way that I look at it and the way that I tell everyone that I have the pleasure of working with, I tell them that don't prepare for the questions that you know are relevant. Prepare for every single question, relevant or irrelevant, which could be asked by a judge who has not read the file, because that is the test that you will have to essentially uphold when you're in the court. And I will tell you very frankly, you'll be amazed by the kinds of questions you'll be asked in court, because the judges tend not to read all those files beforehand. And you can't necessarily blame them. They have 50, 60 files per day. I mean, it's actually humanly impossible for them to be able to read all those files, right? So they're not going to read all those files. They're going to try to go off what you're arguing. So there will be lots of situations in which they will be arguing, or they will be putting out positions which are perhaps irrelevant to what you're trying to put before them or the question before them. But in order for them to understand that point, you would have to address what they're saying. So if you haven't prepared for those irrelevant questions, you're not going to be able to answer them. And if you can answer them, he's not going to come back to the actual relevant ones. So that's extremely important. And, those are things that we should keep in mind whilst arguing. Now, I've just put some bullet points out there, kind of just get people thinking. Um, we can, because I do see there's some questions coming in. So perhaps we can take some questions right now and then, proceed from there. Aisha, do you think that's fine?
Yes, yes, absolutely fine. We have one question in the chat box, and three students have sent me personally questions as well. So how
Okay.
do you want to go about
Okay,
that? You
so I,
want
I I see the Mariam Asad, I believe, has sent a question. I'll just read this out.
yeah.
When you say you're a judge, what are some ways you suggest that we get to know them, especially as new practicing lawyers? Okay, so that's a good question. So this is where experience comes in, right? So um, whenever you're new to court, obviously you're not expected to know that judge, but you obviously have seniors with you. You have senior counsels with you. You'll have a partner with you. You'll have a variety of opportunities to be in court. So it's going to be a mix of things. So number one, you'll know thy judge. And by know thy judge, I don't mean you actually have to personally know him. Obviously, you don't. By know thy judge, you have to know the kind of judge he is for the purpose of your cases. So for that, your senior counsel will be extremely helpful in that. They'll be able to tell you what their specific likes or dislikes are, what kind of things they prefer, what they don't, what cases they like, which they don't like. A lot of those things will be answered by those individuals who you are working with. Another way is in court, right? So when a lot of you will be starting out, you will be appearing in court. Now, this is what we call counting numbers in court. कि कोर्ट में आपको खड़ा कर दिया जाएगा, सीनियर कहेगा जी आप अकील अब्बासी साहब के कोर्ट में, आप तो खैर वो सुप्रीम कोर्ट में, बट लेट्स शफी सिद्दीकी साहब के कोर्ट में आप जाएं एंड उधर बैठ के जी आप मुझे नंबर गिन के दें, कि कौन कौन सा नंबर कॉल हो रहा है. Because serialized the cases are called serial wise. So essentially, if there are 50 cases, your case may be at serial number 28. So they're going to tell you to sit there from serial number 1 onwards and just keep updating them about what serial number it is, so that eventually when 28 comes, they know and they'll come and appear in that case. So a lot of you in the beginning will be doing something as mundane and boring as that. But as boring as it is, it's also quite helpful. Why is it helpful? Because exactly what Mariam was stating over here, how do we find out about judges? That's how you find out. When you're in that court all day and you're listening to what that judge is doing with other cases, how he's responding to other lawyers, you understand and you start appreciating what kind of a judge he is, and what you should and should not do. And I think when you appear in court, when you sit in that courtroom, even if you're not appearing before the judge, if you just sit in that courtroom and you spend a day over there, even if you don't find out what you should do, I can assure you, just by the conduct of the lawyers as well as what the judges are saying to those lawyers, you will certainly know what not to do as a lawyer, right? So even that in and of itself is extremely important, right? So I think that's how you'd want to be looking at it. And over time, once you make your personal appearances before these judges, you will gain that knowledge and you will start understanding how these judges tick and what pet peeves which judge has, and then you'll try to cater for that accordingly and make sure that you kind of just tiptoe around those issues rather than kind of go ahead. headstrong into them. There any? Okay. Okay, so that's the first one. Okay, I'm not sure this is a common. Okay. Judges do not pay much attention to the young lawyers or their arguments. However, when similar arguments are made by someone older, they are considered. How can a young lawyer overcome this? Absolutely correct. And it's actually quite funny because something like that happened to me when I was a junior lawyer. So I remember very clearly. Um, I was in a courtroom, and I won't take the name of the judge. It was the division bench, I remember, and I had prepared the case with the senior counsel. So I knew the case inside out. The senior counsel at that time was busy before another bench. It was a contempt issue. So I went in court and I essentially explained the whole matter, like, A to Z, everything, what the problem was. And the judge just tore into me, like, no, this is wrong. This is not how it is. And this is not contempt. And this case doesn't make sense and this and that. And he said, call your senior right now. And I'm keeping it aside and tell him to come and meet me right away. I said, okay. And I thought that, I mean, he's not satisfied with our arguments. He doesn't get it. Um, and then I called my senior, and my senior came in, and my senior literally just said the exact same thing that I said. And the judge was, for all of a sudden, he seemed to think that, the argument was valid and it was absolutely correct. And he was totally on our side then. So yeah, you're right. I mean, that happens, and it's frustrating, it's unjust. But so the way that I look at it is this, and I think it's frustrating, but it makes sense to a certain degree as well. So that senior counsel who appeared and came before that judge and the judge who listened to him, there was a reason for both of those things. So that senior counsel, when he came to that judge, he's developed a certain reputation along the years. After developing that reputation, when he prepares before that judge, the judge takes him more seriously. He'll take him, he'll give more weight to what he has to say as opposed to me. Now, the question is, why would that be? And the reason is, I think, pretty simple. He's appeared more before that judge. That judge has seen him. He's been able to argue before him, and he's made reputable and good argument before him, and good enough arguments before him that the judge feels that this guy won't lie to me, and this guy will be upfront, and this guy has good, intelligent arguments to make. So if he says something, I should at least listen to it. Now, as a junior counsel, I at that point in time wouldn't have argued before him. So obviously, he wouldn't give me that same regard. So he'd be extremely tough with me. He wouldn't be willing to hear me out. But it's not it isn't exactly the situation that you'll never get a chance to argue. I mean, I can tell you the first time that I argued was a review application in a petition for Justice Sajjad Ali Shah Saab when he was in the High Court. And I remember he was very strict with me, and he was very he had lots of questions, and it was a pretty intimidating to be your first arguments. And it went on for about 1.5 hours. But what happened is, okay, after that tough time that I got the first time, the next time it became easier because he knew that this guy can argue. He has prepared, he does prepare. And so with that small little act, I started gaining a reputation, right? And you don't have to argue for 1 hour, 2 hours, 3 hours to gain a reputation. It's multiple appearances, right? So you may appear before a judge in like 10 different matters. Only one may have been argued totally. But if the judge sees you as reasonable on the other 9 occasions, he's seen you being able to, being able to carry yourself. He sees that you're researching and you've done your research. It stays with the judge. So it may not come out in the first opportunity, the second opportunity, the third opportunity, but it does eventually come out. And it's the same for everyone. It was the same for me. First 2, 3 years, difficult. Judges don't give you the time, the day or the time. But eventually, when you do argue, because you do get to argue, it's more difficult, but you do get to argue. And yes, they are less likely to listen to you, but they do understand that you are a new lawyer, and they will be judging you on two criteria. Does he know his law? Can he carry himself? Can he take pressure? If you can do these three things in any argument, short or long, before a judge, you will start developing a reputation that will eventually allow you to go for a judge and say, okay, my lord, I feel the case is to go this direction. and the court will, to a certain degree, give you deference, right? So it's experience. You just have to keep at it, and you have to argue as much as you possibly can. That's the best way. Some people say that, associate yourself with a senior counsel and standing by him would allow you to gain that reputation. It doesn't. Uh, if you stay too long just side by side with a senior, you will be associated as an associate of that senior for the longest period of time. That doesn't help. The only way to get out of this mold is to go directly and argue matters, chote mote kuch bhi ho, just argue, right? And argue with proper preparation, and you will start seeing results. And that's the only way, unfortunately, that you can get it done. Okay, so we've done that. I hope that answered the question. If there's an add-on, then obviously please do let me know. Um, okay, so when selecting their first client, what 2, 3 points should every lawyer look at? So let's just go at that first. Um, okay, so I mean, when you're looking at your first client, I think the criteria is a little different. Um, they say that beggars can't be choosers. So I think that usually is the case when we're all starting out. We all want that first case. We all want to start out, do something, get into that action. And so we're not necessarily going to be the most picky when it comes to our cases. And that's okay, right? That's fine. You don't have to be very picky. But there are a couple of things that you should definitely be keeping in mind. Don't take frivolous cases. Um, because the problem that you'll encounter is that if you take on frivolous cases, then what starts happening is judges will associate you with being frivolous in terms of the kind of outcome cases that you're bringing to the court. They'll assume that you're not serious. And the reputation that you will gain is not a reputation of a serious lawyer who's a thinking lawyer, who's bringing decent cases. You'll get the reputation of a lawyer who's essentially just taking on anything that he can get for a fee. And therefore, the judges take you less seriously. So don't take frivolous cases just for the sake of a brief. Don't do that. It's never a great idea. And it can be extremely embarrassing in court. Number two, make sure that the client, even if he's not necessarily, even if he doesn't necessarily have a 100% case, that's okay. 50% arguable be here, that's fine. But the client needs to be someone you can trust. And by trust, I don't mean you have to have blind faith in him. You can understand that, you can know that. But you should not get the sense when you meet that client that he is shady, that he's hiding something, and he's not being upfront with you. Because your client has to be absolutely upfront with you. If he's not being upfront with you, there's a problem there. And it may come out later in court and you would be embarrassed. So there's a couple of points that you'll want to keep in mind. It is definitely these things. And as far as the fee is concerned, because that would be the third element that would be most important for you, the fee should not be a big part of it. When you're taking on your first cases, keep your fee low. Don't worry about that. Get that case, do well in that case, and you will start seeing that client will either come back to you, and if he doesn't, by word of mouth, he will tell other people about you. And because you have a good fee structure or a low fee structure, you will start getting people towards you. And that's just how you start. And eventually, when you start gaining a reputation, you can start setting your own fee structures, which kind of cases you want to take and which kind of cases you don't. Are there any courses or skills students should start learning if they are thinking of joining litigation in Pakistan? I think the only thing that you really need a lot of is patience. That is just like number one. I think most people that I see who leave the profession find it demoralizing because they feel they're underpaid, overworked, and they're not willing to put in the 3, 4 years that they need to get ahead in the field. Now, no, there's nothing wrong in that. I mean, they just may want separate or different things, fair enough. But you just need a lot of patience. You need to be passionate about litigation because if you're not, you're not going to be able to put in the long hours. And as far as skills that you may want to hone in on before entering the litigation field, I think, you know, the basic skills that you need to know is ALD research. You should know how to research. And I don't mean Pakistan law side. Pakistan law side, as far as I'm concerned, is an absolutely shabby way of researching. It's not complete. It's not proper. It's the lazy man's, research tool. So don't be someone who comes to an interview and says, "Okay, yes, I'm great at research. I know how to do PLS." That is just not going to cut it. You should know your ALDs. It's manual, but it's effective. Your annual law digest essentially. as to how to research. You should be able to go through the PLDs and all the other research tools, and you know you should be well acquainted with it. You don't have to know everything, but you should be well acquainted with it. If you are well acquainted with it, I think you're probably going to beat about 7 out of 10 applicants to any job interview. So yeah, are there any tips, tricks we can use to effectively prepare for a case? Well, I mean, I think case preparation is different for everyone, so I don't know if I can give you any specific tips. I can tell you what I do, and I kind of hone this, skill for myself and according to how I prepare things. So I'm not the kind of guy who likes winging things. So I don't like just, appearing on a court date and just saying, okay, let's just see how we're gonna take this. I like to be well prepared before any court hearing. And the way that I like to do it is that, for example, if you're appearing for any XYZ judge, let's assume you're appearing before Justice X on any given date. What I would do is I tend to go to that courtroom, or I would go to that courtroom at least for like a couple of days before the date of hearing, just to ascertain, what that judge is doing, how he proceeds with his cases, what he likes in advocacy, what he dislikes, whether he likes lengthy arguments, whether he's to the point, whether he'll give you the time of day, or whether he will not, whether he's going to be impatient, patient, he's an angry judge or a happy judge. All of these things are things that I will ascertain prior to the date of hearing. I won't leave it for the day of the hearing itself. That's probably the worst thing you can do. Go beforehand, check these things out, know what you're getting yourself into, and then prepare your arguments accordingly. If it's a judge that is going to give you a patient hearing, you prepare your lengthy arguments because you want to make sure that it is pretty much engraved in his mindset, whatever you're trying to say. If he's someone who likes to get to the point, he doesn't like to wait, you don't want to prepare lengthy arguments. It will irritate him. He will essentially decide against you just simply because he will be frustrated by how long you're arguing. You'll have to make them concise, truncate those arguments, make them extremely concise and precise so that you get to the point extremely quickly. These things you have to do. In preparing the arguments themselves, I usually put them out in paper, uh, but I rehearse them in my head. I go through them. I visualize the kind of arguments that I will have. And the most important aspect of my preparation is I always think of what questions the other side will ask, what questions the judge could ask. And, if I was the other side, what questions would I ask? What are the weaknesses in my case? And I would identify every weakness in my case, and I would try to plug those holes before I go into those arguments. Because if I can address every loophole or every weakness prior to the hearing, then I won't be surprised on the date of hearing. So those are the things that I would do, and that's the kind of things that you should be looking into, perhaps, if that's how you want to do it, when looking into cases and how to prepare for them. And what tips would you give to engage with the other party's counsels, who usually are rude while maintaining the court decorum? Also, can you give some general tips on art of advocacy? So, Mariam, that's a good question. And I think, frankly, um, this applies a lot more to women than I think it applies to men. It applies to men as well and newcomers in terms of advocates when they're guys. But what I've seen is that it applies a lot more to women because I think a lot of advocates, whether they're senior or otherwise, think that they can get away with it in court. So there are a couple of things that you need to keep in mind. Obviously, please maintain a thick skin. You'll have to, and that goes for everyone in the profession. You're going to see a lot of different types of lawyers over here. So you're going to have to deal with all of them. So that there's not much you can do about that. But what you can try to do is manage the situation. So what do you do when a lawyer is being rude or angry? So what I've noticed is that if a lawyer is being angry or somewhat rude to you, um, the worst thing you can probably do is just let it go. You let it go, it gives them the license to continue that, right? So that is what I've seen. So usually, if someone has ever tried to do that with me, I've replied to them in a similar fashion. Obviously, respectfully, if they're being abusive, I'm not going to abuse them in court. We have to maintain our red lines as well. But I will certainly push him back in terms of my response to make sure that he knows that if he's going to say something, he will get a dignified but an objection to what he's going to say. Now, the reason I'm saying an objection or I'm going to give a dignified response is because I'm not trying to say that if he's going to the gutter, you got to go to the gutter with him. Please don't do that. It doesn't serve you well. Um, what you need to do is you need to essentially make sure that that individual, whoever he is or she is, realizes that any kind of personal remarks or any kind of remarks towards you or rudeness towards you as a counsel will be met with a response from you, right? It will not be brushed under the carpet. You will not allow it to go. Um, what this does is, number one, puts the other counsel on the back foot a little bit. And number two, it forces the court, because it's actually the judge's job to maintain decorum. And unfortunately, a lot of judges don't do that. And it forces the judge to step in and kind of then maintain decorum in the court. So, I mean, that's one thing. Whilst doing this, please keep in mind two things. Sometimes it's actually better to let the judge, let the lawyer, lose his cool or be rude in court, because sometimes it adds to your case or it helps your case. That is a tactical decision that you'll have to make. Sometimes people will do it, sometimes people won't, sometimes people will lose their cool, sometimes people won't. But sometimes I will reply to them and make them push back if I feel that it's warranted, and if I don't do it, it will affect my ability to get through the judge. In other instances, I will know for a fact that him doing that will actually piss off the judge or irritate the judge or frustrate the judge to such a degree that it actually serves my purpose if he becomes a little, if he loses his cool a little bit and says things which are essentially not going to help his case and are just ad hominem attacks. So then that's a tactical decision. But whatever you do, in whichever circumstance that you find yourself in, please do not lose your cool. आप खुद अपना cool ना lose करना. Uh, because if you lose your cool, you will inevitably do something that will take away from the merits of your case and go into something that will be absolutely irrelevant. Keep your cool, do answer them, but keep your cool and always maintain your eyes on the goal, which is to get your case across. You do that and you'll be fine. But long term, you're going to face lots of lawyers like that. Women do, men do, and you have to learn to be able to stand tall in front of them and not back down. Essentially, when someone tries to do that, they're trying to make you back down. Just don't back down and make sure that they know that you're not going to back down from your case. And eventually, what I've noticed is a lot of them actually do back down. And those that don't, it's fine as long as you're getting your orders and you're getting the cases decided in a fair manner. You don't have to be friends with them. They don't have to be friends with you. You just have to get your case across. Um, can the first case break the litigation career? No, it cannot. That's not how it works. So imagine yourself, or like imagine yourself in university where you have multiple teachers, right? So a teacher may have a bad class. She may not teach very well in one class. Um, but nonetheless, at the end of the semester, she have great raving reviews. And the reason is that you may have certain bad days. It's expected that you would. That's not a problem. But if it's routine, if it becomes a pattern, then a reputation sticks. So any teacher who's good at his job but is having off days will be recognized as a good teacher who has some off days. Any lawyer who has one bad case but it brings other good cases will be recognized as a lawyer who generally brings good cases. And sometimes the cases that he brings are difficult and not great, right? Uh, the reputation is established not through one case. It's established through a series of cases and the kind of cases you're bringing. So if the kind of cases that you repeatedly bring are cases that are clearly frivolous, the judge will recognize you as such and will label you as such. If not, if it's just a one-off case, you'll get past it. I mean, judges are not that unforgiving. They understand that things happen, and they've been lawyers themselves as well, so they know where the practice goes and how it starts and how it ends. So it's not that dire. But yeah, try your best to be as you know as intricate and as detailed as you can in terms of case selection, but Um, it's your case selection shouldn't be based on the fact that I have a slam dunk. That's not how it is. The test that I use for myself in selecting cases is the case arguable? If I can take that case and make an argument that is arguable and which will not lead to any embarrassment to me, then it is a case that I feel that I can take. If the only arguments that I can take in any case are embarrassing, are so patently innocent of the law that it just makes no sense for me to make them, then that is your cue to just take a step back and not take that case. Right. So that's a decision that you're going to have to take. That's a red line you're going to have to kind of set for yourself. What are some ways through which we can keep ourselves updated with the latest laws, amendments, judgments, jurisprudence? So, I mean, the Supreme Court website is a wonderful tool. So, I mean, you'll have all the latest judgments on it. So, even I go there, once a week, perhaps even more so than that, and check out what the latest cases are, what judges are saying, what the judgments are saying. Um, Now, I don't know, a lot of you may not have access to this, you may, but every month a digest comes out, a PLD or CLD, CLC, which have the latest cases in them, other than PLS, Pakistan Law Site. So you can go check those out as well, read up on that. And generally just keep abreast of, new jurisprudence developing around the world, the US, the UK, and India. I think those are the most important jurisdictions for purpose of Pakistani law. So, I mean, just look around what's happening, Roe versus Wade, what happened before, the new judgment that came out, what happened then. Just keep your ears and eyes open. And if you're looking specifically for Pakistani law, the Supreme Court website is a great way to go about it. And you have monthly digests that come out. And you can go to any bookbinder who deals with legal books, and they'll be able to supply those to you. And you can also look at those for purposes of legal knowledge. And then obviously Pakistan law site hai hai. What advice would you give someone just starting out in law school to make the most of their education experiences? Okay, so question four. I'm not sure as to, this is a very broad-ended question, so I'm not sure exactly what you are asking in relation to this. I mean, as
Should I give a little background about
yeah,
the
yeah,
student? Yeah.
absolutely.
So he has just started. So are you familiar with the BA LLB program that we have over here? So
Yeah,
the
I
student
went
is
through it.
done
I was
with
the first
the
batch.
so yeah. So the student is done with the BA part, and they are just starting with the LLB part from September.
Okay.
Yeah. So
Okay.
they're just
So
on the starting case.
okay, what advice would you give to someone just starting out in law school to make the most of their education experiences? Okay, so I mean, you've also already started your LLB. I think a lot of people advise कि internships करें, ये करें, फलाना करें. Yeah, it depends on what you're looking for. So when I entered law school, I was very clear that I wanted to be a litigator. There was no qualms in my mind that I wanted something else or this or that. I was very clear that this is if it's going to be law, it's going to be litigation. Otherwise, I'm not going to do law. So from that perspective, I never did any internships. When I was in law school, I straight up went into uh, after graduation, I entered into the workforce after my master's. Um, so I mean, it just depends on where you are. If, for example, you are at that stage in your career where you're not absolutely sure if you want to be in a corporate job, in a litigation job, in an in-house job, then look into exploring some internships that could help you. Perhaps in 1 year, um, go in-house, see if you can get an internship over there. In another year, go in a corporate place, and in 1 year, go to litigation. You have 3 years, right? So you have three opportunities at the very least. Go to each one of these places and see what you like, and if you find you are interested in one more than the other, then perhaps that's where you start off. um, Other than that, I started writing for newspapers when I was in LUMS. That's when I started it, and then I continued afterwards as well. That helped me quite a bit in a lot of things. It helped with the Fulbright application that I subsequently gave in, as well as getting into a university for my LLM, as well as when I came back for applying for a job. I think one of the most important, one of the most standout things that I had on my CV were the publications, and I think every employer noted it. So I think you have a lot of competition now, right? So uh, being an LLB right now is something that everyone is expected to be. Um, there was a time when you would be doing your vocational courses and that would be enough. I think now you have to go even beyond that. So, I mean, you want your LLBs, you want your vocational courses, you want your New York bar exams, you want your LLM. So, I mean, if you want to stand out, there's a lot of things you can do. I mean, just depends on how you want to do it and when you want to do it. Some people will want to be doing this right after university. Some will want to wait and get a couple of years of experience and then go for their LLMs and then come back. I mean, so it just kind of depends on you, I think, and it depends on where you are in your mind right now. If you're if you're sorted, if you know you want to get into litigation, then I would say just focus on your studies, do a little more extracurriculars, try to write in newspapers, try to you know I believe एक जमाने में LPS होता था उधर Law and Politics Society. I believe it might still be there. So I mean, get into these organizations, these societies, contribute there, meet people. I think that's what's going to help you eventually when it comes to your overall experiences and your education. What advice would you give to someone unsure about which path to pursue? I think I kind of just delved into that right now. And how can one gain clarity on the preferred specialization? Can clerkships, internships help me? So yeah, I think I kind of answered this. So internships will help you with that. But the one thing that I would tell you guys is that don't worry so much about this. Um, you'll have a lot of time in the first 3 4 years to kind of figure these things out. So yeah, do internships. Internships will give you a flavor of each type of place, whether it's in-house, corporate, or litigation. So get a flavor of that if you're not sure. Then enter the workforce, and then you can always experiment a little bit in the first couple of years. That's not going to harm you. But what I would suggest, and this is what I tell everyone, uh, never start off in-house. That is probably the worst thing that I feel people can do, because it's difficult to leave in-house and get back into litigation and corporate. But it's a lot easier to leave litigation, corporate, and go in-house. The reason is the pay scales. You'll find the pay scales to be a lot better in in-house jobs right now in the very beginning than you'll find it in litigation or the corporate world. Corporate में फिर भी थोड़ा comparable होगा, but nonetheless, in-house will definitely be better. There'll be better perks, more benefits. So it's always harder to leave perks than it is to gain them. So, and number two, I think generally the work standards or the rigor involved in litigation and corporate work is a lot more than in in-house jobs. So you'd want to start off over there, see if you like them, and if you don't, then go off into the in-house, arena. And it helps because any experience you have in corporate law, in litigation, will get you a better pay scale in in-house and will definitely get you a better job in in-house anyway. So if you were to look at a career path and how to do it, go for internships. And then after that, if you're still unsure, pick something that you like. Like if you're interested more in corporate law than litigation, start off there. If you want to change, then you could change into litigation subsequently. And if you want to kind of hedge your bets, the best bet is to go into a law firm which has both, and you'll find quite a few that do have both. So go there, and then perhaps if you are tired of the litigation side of it after like a year or two, you can just switch within the same firm to the corporate side. So I mean that's also a possibility. Clerkships are helpful, definitely. अच्छी चीजें होती हैं, but I don't think they will necessarily help you in deciding what you want to do, because I think clerkships are a totally different domain. Um, so definitely great experience, especially if you want to do an LLM, a master's or something else. Great, great to have on your CV, and definitely a great recommendation that you can get. So I mean, from that perspective, great. For a litigator, it's definitely something that's very important, and I think it serves their purposes for greater progress in their career. But in terms of trying to figure out what you want to do in life, whether you want to be a litigator, corporate, or want to go onto the corporate side or in-house, I don't think it's necessarily going to be that helpful on that front. How to start the final arguments? What part should we focus on the most? Facts, law, evidence? Well, again, that will depend on each case, but generally speaking, when you've led evidence, everything's done, and you're in final arguments, the most important aspects of your file will be the affidavits and evidence, the exhibited documents, which are the evidence, itself, the reply that they've given or their affidavit and evidences, their examinations, their cross examinations. Those are going to be the most important documents that you will have to utilize for purposes of your final arguments. There can also be preliminary issues such as limitation, other maintainability issues with the case. So that can be argued as well. So what I generally do is that whenever you are in final argument, what you will see is that um, court ने already issues frame किए होते हैं. So keep those issues before you and then start preparing your arguments looking at those issues where you can bifurcate every argument neatly into every question. Great, do that. And in certain situations, the issues will be overlapping, so you can't really bifurcate it. In which case, you mention the issues to the judge, and you specifically tell him that I'm starting off here, and after this argument, then I will be making this argument, which will essentially address questions 2, 3, 4, and then give the judge an outline of exactly how you're going to be taking it, what arguments you're going to be making, gist of it, the summary of it. And after you've given him the summary, so the judge knows exactly where you're going to start, where you're going to end, where you're going to take it. So he's in tune with it. Then you start with the detailed argument. Start with the facts, take him through the facts, go through all of them, then take him to the legal propositions, and then start with those. And in the end, what I usually like to do is I usually like to take out contradictions in the examinations and the cross examinations of the opposing side, so as to kind of weaken their stances. So that's just generally how you can think about going about these things. Can you share your motivation to keep practicing law in Pakistan and how you would weigh your experience of choosing practicing in Pakistan instead of practicing abroad? Um, so yeah, I mean, I think when I initially decided to come back to Pakistan, I think I graduated in 2008 from LUMS with my BLLB. I went on the Fulbright scholarship to Columbia University straight away, did my LLM from there, and then did my New York bar from there, got my New York bar license, and then I made the decision to come back to Pakistan, and I've been practicing ever since. Some would call it delusion. Others would say that, perhaps you came back at a better time and, you should revisit it now. But, I made a decision then, keeping in mind, what kind of a lawyer I wanted to be. And I think, it was the right decision. Um, and the way that I looked at it then, and the way that I look at it even now, is that um, when you're practicing in America, in the UK, or whichever other country you're going to be practicing in, you're always going to be practicing as a second option lawyer, as far as I'm concerned. Not in all circumstances, but someone who's studied all their life in Pakistan and then gone to America for their masters and then taken our license. Um, in more situations than less, any client would be wanting to engage a lawyer who will be 100% born and bred and who's been educated in that very same country, who's been aware of that country's laws throughout their life. Um, and a lot of lawyers who do come from our area or from our country and go over there, they tend to be pigeonholed into certain areas like immigration or family law or stuff like that. So I think that was one of my concerns that number one, didn't want that. Secondly, and I think more importantly, and I think the main concern for me was that I felt there was a lot more to do back home than there was over there. So yeah, you can be another brick in the wall in America or in the UK or in any other country, and you can perhaps and you will probably make good money over there as well, much better than perhaps what you'll make over here. But the opportunities to make changes over here, the the ability to actually argue a case and bring about changes in actual changes in people's lives. I think the ability over here is a lot more than you'll find over there. Um, the kind of skill sets that you can employ over here to actually better the system, that's also needed. You have a system that is overworked, underdeveloped. You have a system which does not have great judges. I mean, it does have great judges, but it needs better or more of the good judges. You have a system which um, puts a lot of weight on only a small number of lawyers because the qualified number of lawyers, although increasing now in Pakistan, are still
very few compared to how many lawyers you need for the kind of cases that you're seeing in Pakistan. So there are lots of opportunities. There's lots at stake. There's lots to improve over here, and generally, I feel it's just a little more fulfilling. So I think there's a lot more ownership over here when I'm working here, and I enjoy it a lot more. And if I do something in public interest, perhaps it's a building violation issue or just generally in relation to regulatory laws over here, I think the self-fulfillment that you get from that is a lot more over here than you'll probably get anywhere else. Considering you were born here, you're bred here, and you're kind of just, you've seen everything over here. So yeah, so I think from that perspective, that was my motivation. And even otherwise, if you're looking strictly from the perspective of you know how well you'll do over here compared to abroad, let me put that into perspective for you. A good lawyer in Pakistan, I think, can make a killing when it comes to money. There is an extreme dearth of good lawyers over here. There are very few good lawyers, right? And the opportunities that you will get as good lawyers, people from LUMS or elsewhere who can speak well, advocate well, who are intelligent, who can research well, who are diligent, who are ethical, um, they can make a killing because clients actually do seek out such lawyers. And you'd be surprised at the number of clients who've come to me simply on the basis that they said that, we've been told that you won't be bought out by an opposing client, or someone else can just purchase your services or get you to tank a case. um, you know that's very small in terms of, that's just the very minimal standard for any lawyer, that they shouldn't be bought out. But you'd be surprised at how many lawyers are bought out and how many lawyers do have ethical problems over here, and you need better lawyers. And so if you come here, you'll essentially be a big fish in a pretty big pond. Whereas in America, I think you'll be a small fish in a very big pond. So lots more advantages, I think, over here if you kind of want to stay here. Um, Also, how can one start writing for newspapers? What are some things that they should keep in mind, and how should they approach the newspapers? So, okay, so my greatest problem was that I had no sources when I started writing for newspapers. No sources whatsoever. I didn't know anybody. So I did what every patriotic Pakistani does. I just started spamming all newspapers with articles, and hoping to God that they would, someone would take something. I was lucky, I guess. The Friday Times, I think, was the first publication that took an article of mine. And when they ran with that, then I started writing into Dawn, and then to the news, and then the Daily Times, and a variety of the papers. And then, as again, like with litigation, once you keep writing and your pieces get a bit of traction, the editors start recognizing you, the people start recognizing you, and it becomes easier to give in those articles because they know that, you do these things and you write these articles and you're fine and you're fair about them. But initially it was difficult, and how I did it was, and I'm guessing any of you people, those of you who would be interested, when you go to the news.com or dawn.com or all of these other websites, they'll always have um, web pages or email addresses where you can send articles or pieces to the editor or the editorial staff. So that's where I used to send it. And, I got lucky. And it took a lot of perseverance, by the way. अमूमन तो पहले तो कभी कभार जवाब ही नहीं आते थे. And I think I was to the first response. That's when it just started snowballing from there. So I think you just have to be persistent, keep trying. And you don't have to necessarily start with the Dawn or the news. Start with small publications. The Friday Times is actually pretty good when it comes to these things. They allow a lot of people to write things in relation to a variety of different things. You don't have to be political. You don't have to write about legal issues specifically. I think the first article I wrote was about my trip up north or to Gilgit-Baltistan and what I saw, and the traveling up there and all of that stuff. So I mean, magazines like that, there's the South Asia Pulse, I believe, a lot of smaller magazines. A lot of them give opportunities. So try to explore those and then work your way up towards these other publications as well. So yeah, when is the best time to go for an LLM? And are there any key factors one should keep in mind when deciding which LLM program to opt for? Okay, so I went for my general LLM, and the reason was when I went into litigation, I was sure that I wanted to do litigation, but I wasn't sure as to which part of litigation, which side of litigation, whether it was the corporate side, the civil side, the commercial side, the family side. I wasn't sure about that, so I preferred a general LLM, and that allowed me to pick different subjects so that I could get a bit of a flavor of pretty much everything. And that served me well. It helped me out. But as to what is the best time for your LLM, I mean, again, if you would ask me today, I would say um, if I could have joined the legal profession in 2008, spent a couple of years in the legal profession, and then gone for my LLM, the absolute best thing that could have happened. Because that would have given me certain experiences so that I would be able to draw on those when I would be studying in my LLM. Um, so that is the best possible way that you can do it, but it's not possible for everyone. It's like I didn't do that. I went straight after my LLB, and the reason that I did that is because I knew myself well enough to know that if I ever enter into the workforce, I'm not going to go for my LLM. I'm just not going to do it. Because you'll start making money after a couple of years, you'll start getting settled, a little comfortable. You'll be less likely to want to venture out. It becomes a little more difficult. So I was already in the study mode. I just completed my LLB and I thought, okay, this is the best time. Let's just head out right now and get this done with. And I think I made the right call for myself. But those of you who have better or more willpower than I do and are able to will be able to, spend a couple of years in litigation and then go for the LLM, do that. You'll enjoy it a lot more in that way, I think. Um, and any other question? We hear many sources saying that there is no work-life balance in litigation. There's anywhere. In there, any way the graduation batch could incorporate in their routine to ensure work-life balance than starting the litigation career. I hate to break it to you, but those seniors are correct. My initial years in litigation were horrid when it came to work-life balance. I think initial years, may, if I'm not mistaken, I was on average in office till around 1 a.m. every day, and I would be in court at 8:30 in the morning every day. So that was the average. When my life got better after 3-4 years, my average was 10:30 at night. I would leave for home. Now it's a lot better. Now I make it my aim to leave around 7:30, 8 p.m. every day if I can, if there's no urgent work, so as to prioritize my life over work, or prioritize my life and my work, like balance them out. But it comes after quite a bit of time. So I mean, it's taken me quite a few years to be able to establish that life-work balance. So I think that is something that you guys will have to kind of reconcile yourselves with. It will take a toll on your social life, and I think you have to kind of sacrifice your first few years for this profession. If you're able to do that, you'll go far. If not, then you'll still go. You'll still be able to do decently over here, but perhaps not as well as you want to do. Um, okay. Well, I don't think you can do your LLM without a BLLB. You'll have to just check an individual university. But I remember that the BLLB was important for that and it was required for it. The only alternative could be that you have a JD, which is the LLB equivalent in America. Then perhaps you can do it. But otherwise, I think you would need either some form of an LLB or LLM. And I'm not sure if you can just do it on the basis of an LLB either. I was lucky that I had a BA and an LLB, because in America as well, you need a BA degree or a bachelor's before you can do your JD. So from that perspective, the LUMS degree kind of helped me out over there. So I'm not sure if you can just simply do it with the University of London degree, and you can just go straight for LLM. You may have to take some additional courses. I'm not sure, but I guess the individual university websites could help you out with that a lot more than I can. So yeah, so I think we about covered all the questions, and I think if we don't have any, Aisha, what do we have any more?
I'm not at my end. I think there aren't any more questions, and
Okay.
give them 10 seconds if they want to raise their hands and ask any question. Otherwise, we can move forward. As I believe the third bullet point was still left to be covered. We
Which is
had covered the first two bullet points.
which is the third bullet point? It's client management,
Yeah,
communication, courtroom, and trial skills. So I talked about
trials.
client management. Are you talking about that?
Yep. The courtroom skills is left.
Okay, courtroom skills. Okay, so when it comes to courtroom skills, there are a few things that you have to keep in mind. Now, it also depends on the kind of cases that you're going to be looking into. So I'm going to divide it into criminal and civil. I'm going to give you a briefer on it, and then you guys can just let me know if there's anything in addition to that you want to know. Um, when you're arguing in courtrooms, um, you have to be extremely careful as to how you're going to be taking the matter forward. Um, the most important part of any court case, whether it's a criminal case or a civil case, will be your evidence stage. The evidence stage in a criminal case is a lot more important for the simple reason that, in a lot of circumstances, people's lives are on stake, are at stake. But irrespective in civil and in criminal cases, you will have to lead evidence, and that evidence is pretty much everything. So for those of you who may know that initially when you file your claims or your suits or your cases, there'll be different sides to it. So if you go on the civil side, if you file a civil suit, um, it'll have variety of stages in it. First, you'll file that suit. They'll file a written statement to it, which is their response. Then the issues are framed. Issues are framed. Then evidence is led. You'll bring your witnesses over there. They will then cross-examine them. They will then bring their witnesses, and those will be cross-examined, and then there will be final arguments. That's how our civil case generally proceeds. The most important documentation or the most important stage of this entire process is the evidence stage, which means the stage at which the affidavit and evidence will be submitted by each party, submitting their evidence. The stage in which they will be exhibiting documents. Uh, for us, it's the Qanun-e-Shahadat Order 1984, which deals with how evidence is to be led in Pakistan. So that is very important. You will also have to decide, as to the course of action in terms of examination and cross-examination. When you are the person being examined, you will be subjected to cross-examinations, or your client will be subjected to a cross-examination. So you have to make sure that whoever you are submitting as a witness in those circumstances is someone who has direct knowledge of the case at hand. So whatever you've made or whatever claims you've made, you can't simply bring in an attorney if you want, or any third person who simply was told by someone else that, okay, this is the case that we have, and this is what we're trying to say. If you bring in someone who's only heard about it from someone else who hasn't directly experienced it, it will be called hearsay. And on account of that, it won't be considered by the court. So it has to be a direct witness, someone who's directly heard or witnessed this entire case that you're talking about, who can directly evidence it, or evidence the conversations that took place, the documentation that took place. So you have to specifically bring those individuals in. Whenever there's a case in which you're leading evidence, always prepare your witness prior to cross-examination. So, for example, अगर हम अपना बताएं, so if we're if one of my clients is about to give evidence in a case, we'll call him over to our office. We will tell him that these are the documents you have to submit. We will make sure that does he have the original documents in that case or not. If he has all the original documents, wonderful. We submit those in court, and which will then be exhibited. If he doesn't, then there's a additional step, because if you don't have originals of documents, you'll have to take permission from the court to provide secondary evidence or photocopies, etc. And those are on limited grounds. Either the originals are with the opposing side, there was someone not under your control, or they are documents which have been lost or not traceable. So you have to have specific ground before you can actually bring those documents in as photocopies, and they'll be allowed to be exhibited. So you bring those clients in, you explain all this to them. If there's a situation like that you need to bring certain photocopies in, you will then provide the evidence, provide the application to court, it'll be allowed, and then you'll be allowed to bring the documents into evidence. You will then allow the other side to cross-examine your witness. And for that, you should be essentially going through what possible cross-examination questions that witness can face prior to that hearing. So the biggest problem is that when witnesses are brought to the evidence stage, they don't tend to understand how evidence will progress. So they make mistakes because they're anxious, they're apprehensive, they don't have an idea as to how to proceed. So it's your job as a litigator to bring them into the office beforehand, give them that environment beforehand, tell them exactly how it's going to happen, cross-examine them as they will be cross-examined in court, so that they are aware of what they should be expecting, and then take them forward. Once their cross-examinations are done, that's done with, their side will close, and then the other side will bring in their witnesses. Again, the same principles will apply, and we will then get a chance to cross-examine those individuals. And when we do cross-examine those individuals, we have to obviously keep in mind that we want to break their testimony. So we want to bring out as many contradictions as we can in their testimony and what they're saying. We want to kind of show that they're not privy to the case itself. They don't have first-hand knowledge. They've only talked about it from others, or they've heard it from others, and therefore they don't have direct knowledge of it, and therefore they're not reliable witnesses. So these are the things that you essentially want to keep in mind. We did answer one question about final argument, but I'll just go over that a little bit more. That once you cross this stage into the final argument stage in a civil matter, then you have to essentially you know, create your arguments around the evidence. The plaint and the written statement which were initially given are no longer as relevant. Now it's essentially the evidence that has been led, the contradictions that are present in the evidence, and you have to kind of either help your client overcome any contradiction in his evidence, whilst also bringing out the contradictions in the other's evidence. You should entertain those final arguments by thoroughly preparing the entire case, including the evidence, but by addressing each of the issues that have been framed by the court, so that to make sure that the judge is with you in relation to every single problem that is in the case, or every question of law or fact which may be arising in the case. In criminal cases, it's a bit different because अगर एफआईआर कट जाता है तो एफआईआर कटने के बाद then you will have framing of charges. I'm not going to talk about bail right now because that's a little different, but you'll be framing charges will be framed in the presence of the accused. The accused is to be present every single date of hearing unless he files an specific exemption application. And the complainant, उसकी भी एक complaint वगैरह जो है जब आती है in or in a criminal complaint, then उसका भी एक पूरा अलग process होता है. Right? So in all of these processes, there will be different stages, but the most important stages for them will again be that in a criminal trial, when you're going into the stage of a trial or evidence, um, your job as a defense lawyer would be to make sure that you can poke as many holes as you can into the testimony of that individual or that accused, or of the sorry of the individual who's or the prosecution, sorry. So you have to poke as many holes as you can into the case of the prosecution, so that the argument at the end of the day or at the end of the proceedings will stem around one thing, and that will be that they have not been able to prove their case beyond a shadow of a doubt. Now, you may note that in civil cases, it's a bit different. It's preponderance of evidence. आपने 50.1% पे सिर्फ साबित करना है कि जी plaintiff का case बनता है. Criminal trials are much beyond that. And in criminal trials, unlike in civil trials, the accused usually tends not to take the witness stand. He has the option to do so, but he tends not to because he doesn't want to incriminate himself. So the case focuses in criminal trials about poking holes in the testimonies of the witnesses of the prosecution, weaken their case, bring out the contradictions so as to ensure that they cannot bring it up or bring the case up to the standards of beyond a shadow of a doubt. Whereas in civil cases, it's about looking at the evidence on the preponderance of who's got a better case and on viewing both sides and the testimonies of both sides. So it's a bit different, but in all situations, the skills that you need to have if you want to be a litigator, they have to be in relation to your ability to lead evidence. Because if you're not able to lead evidence, your case, no matter how good it is, it will essentially falter at the very end. You won't be able to prove your case, and it will go out. It will be dismissed. So that's the most important part. Aisha, are there any specific questions that they want to ask about trial skills or what the
No, there aren't
aspects
any
they want to know about
specific
it?
questions that I've received so far, so I guess there aren't any.
Okay. So that's that. I mean, if that's all, then I guess then I guess we can be done with it. If there's anything else, let me know.
We can ask them if they have any questions, and we can give them 10 seconds. So everyone, you have 10 seconds. If you have any question, kindly raise your hand or pop it up, and we'll be addressing it. Otherwise, we'll end the session. So I guess that's about it. Thank you, Basil, for such an informative session. I have almost answered all the questions promptly. I'm sure the students would have benefited a lot. In fact, we had benefited a lot from the session as well. I guess Faraz wants to say something. So Faraz, you can say, or maybe it was an accidental unmute. So thank you so much, Basil.
Not a problem.
Yusra, if
Thank
you
you.
want to ask any question, you can go ahead.
Can you hear me?
Yeah.
Yes, we can hear you.
Assalamu alaikum, Basil. That was a very informative and very, very insightful session. You've pretty much explained everything. So yeah, there are no questions. Thank you so much, Basil, for taking time out of your busy schedules and giving us time, guiding the students. Thank you so much.
Not at all. Thank you so much for having me. And obviously, if there are any other questions, you can ask, guys can email me or, ask me and
Sure,
I'll
sure,
answer them otherwise
sure.
as
Yes,
well.
thank you.
Thank
Thank
you.
you,
Okay.
Pastor, for
Thank
joining
you.
in. Thank you, Yusra, for joining in.
Okay.
No
Allah Hafiz.
problem. Thank you so much. Have a good day.
Thank you. Thank you, everyone. Hafiz.